Welcome to Inside IR, a podcast series by Herbert Smith Freehills that explores the latest developments in the Australian industrial relations landscape.
Hello and welcome to Inside IR, the Australian Industrial Relations podcast, the series that arms HR, IR and legal professionals with the latest industrial relations thinking. My name is Rohan Doyle. I'm a partner in the industrial relations practice at Herbert Smith Freehills, and I'm excited to have joining us today on Inside IR from Melbourne, Senior Associate Mitchell Brennan. Welcome, Mitchell.
Thank you, Rohan.
It's great to have you on your first episode of Inside IR. For those who don't know Mitchell, he's developed a wealth of experience from a whole range of different sources. Way back when, an associate of the Fair Work Commission, Mitchell, in-house at Downer, now with HSF, advising a bunch of market-leading employers in a range of industries, including transport, manufacturing, and also in relation to some major infrastructure projects. So welcome aboard.
Thank you. Thank you for having me, Rohan.
How are you feeling about your first attempt on Inside IR, Mitch?
Some tough acts to follow from amongst our colleagues, but no, I'm looking forward to it.
No, it's good to have you on. We're looking forward to your insights. It has been a very busy period for us at HSF, but for employers across the country managing a whole raft of implementation of new IR reforms. And it's been busy for a range of reasons. We've been running a bunch of test cases at HSF that will dictate how these new industrial relations reforms will be applied going forward. We've also been very busy on the bargaining front. But Mitchell, there is one topic that I've noticed the past month in particular becoming more frequent in terms of being raised by our clients, and I think the interest in it is building. Do you know what that is?
And that's workplace delegates and workplace delegates' rights.
That's right. You do know what it is because it's in the script, but we have noticed increasing attention on workplace delegates' rights. And of course, we covered this topic back in October 2023 when the great Tony Wood gave us an overview of the closing loopholes reforms. And as part of that, gave us a bit of an overview on what to expect from the new workplace delegates' rights which were introduced through that legislation. But there have been some developments since, some important developments that we now need to cover and update our listeners on. And that relates to the introduction of the new modern award workplace delegates' rights term. So Mitchell, let's start at the start. I mean, what is a delegates' rights term?
A workplace delegates' right term is a term of a modern award, an enterprise agreement, or a workplace determination that provides for the exercise of the rights of workplace delegates covered by that Fair Work instrument, and builds upon the workplace delegates' rights that have been inserted into the Fair Work Act under the first tranche of the closing loopholes reforms that came into effect in December last year.
Yeah, so it's clear. I think these terms are going to be relevant to essentially all employers, and we'll take our listeners through why that's the case shortly. But to help with that, we're going to cover four things on today's episode. First, we'll quickly recap on what is a workplace delegate. Second, we'll move to the all-important question, what are workplace delegates' rights? Importantly, those provisions were inserted into the Fair Work Act and commenced operation back in December 2023. So hopefully most of our listeners are already across that, but an important recap there. That'll set us up to move into topic number 3. What does the new modern award delegates' rights term say? Mitchell, you take us through the detail on all of that. And then fourth, we'll wrap things up with a brief explanation about what all this means for employers who have employees to whom modern awards apply, and also for employers who have enterprise agreements. There are some slightly different implications for those two different groups. So Mitch, a lot to cover today. We'll kick things off with topic number 1. Can you take us through what is a workplace delegate?
Yes, a workplace delegate is a person who is appointed or elected in accordance with the rules of a union or employee organisation to be a delegate or representative of employees who are members of that union or employee organisation in their workplace. Workplace delegates are sometimes referred to as shop stewards in certain industries, but each union has its own set of rules that are registered with the Fair Work Commission, and some of those rules will set out the process for the appointment or the election of workplace delegates in respect of employees to whom they're entitled to represent their industrial interests.
Yeah. And we're already getting lots of questions around the definition of a workplace delegate. We've had questions from clients, the effect of, well, how do we really know that they've been elected and it's been done in accordance with the rules of the organisation? Are there caps on the number of workplace delegates that can exist in a particular workplace? Some of those questions have been answered by the new modern award workplace delegates term, which we'll come to a little bit later on. But before we get to that, brings us to number two, the big question: what are the rights of workplace delegates? Now, as we know, mentioned before, there are express rights that were inserted into the general protections provisions, which commenced operation back on the 15th of December 2023. I think it's been a slowish start in relation to those provisions. They haven't received a lot of airplay, and I'm not sure that everyone really knows about them or understands the specifics of them quite yet. But they apply to all employers. And they're also going to be similar rights that will apply to certain non-employee regulated workers that will come into play from 26th of August 2024. Now, for the purposes of this episode, we're going to focus on the employee-employer provisions for simplicity, but it's worth being across those other non-employee regulated worker provisions as well. Now, broadly, there's two sets of provisions that employers need to get across. They're in two separate sections of the Act. The first is a list of employer obligations. Take our listeners through those. And the second is a separate list of workplace delegate rights. It's the second list that relates to the modern award term, which we'll come to a little bit later. So starting with a list of employer obligations, there's three of those, as we know, Mitch, and I'll read through those. Number one, an employer of a workplace delegate must not unreasonably fail or refuse to deal with them. Number two, an employer of a workplace delegate must not knowingly or recklessly make a false or misleading representation to them. And third, an employer of a workplace delegate must not unreasonably hinder, obstruct or prevent the exercise of the rights of the workplace delegate under the Act, an enterprise agreement, workplace determination, modern award, etc. Now, importantly, in relation to all of those obligations, the workplace delegate has to be acting in that capacity, so they don't just get a free pass in relation to all manner of other things beyond their rights and obligations as a workplace delegate. And those obligations don't apply to conduct required by law. So if the employer has to do something in order to meet an obligation they have under the law, then it doesn't matter that that might otherwise have been said to contravene these obligations. But there's some pretty general concepts there, Mitch, that are going to present some interesting issues as the cases develop. I mean, what does it take in order for a refusal to deal with a workplace delegate to be unreasonable versus reasonable? I don't know if you've got any views on those particular aspects of the provisions.
I do. I think that the test of reasonableness around the requirements to engage and deal with workplace delegates in this context will be largely contextual. It'll be within the realms of where workplace delegates have traditionally been involved in representing the industrial interests of employees. So during workplace consultation, during the dealing with workplace disputes and things of that nature, I think that they will that context will set the boundaries of what is reasonable and when it is reasonable to engage with a workplace delegate. But there will certainly be the sort of converse, where it is not reasonable to deal with them, and that's where things sort of step outside of the realm of the representation of industrial interests and sort of steer more into the exercise of managerial prerogative and things like that by employers.
Yeah, but I mean the difficult issue is, of course, two of the three of those obligations turn on a reasonableness test. And I should mention that the burden of proving that something is not unreasonable lies with the employer. So this might be quite difficult in the context where a lot of these issues are going to come up with no notice in real life in the workplace, and managers of employees are going to have to be equipped to make decisions in relation to how they deal with delegates on the run, so to speak. So I'm already aware that there are employers out there coming up with scenarios that they expect to arise and some playbooks as to how they will educate their managers to deal with those scenarios. I think that's a very important thing to do, because just reading these obligations as they appear on the page, it's very difficult to conceptualise how they're going to apply in any given scenario. So it's, I think, important in my view that some advanced thought be given in relation to those things. That brings us to the second list that I mentioned, so the list of workplace delegate rights. Now, these are the rights that are covered off in the award term, Mitch, that you're going to take us through in just a moment. Importantly, employers are automatically deemed to have complied with these obligations that I'll take you through in a minute if they comply with the relevant workplace delegates rights term in the award or agreement that applies to the employees. So it's a deeming provision that, in a sense, makes it easier for employers to understand what some of these more generalised concepts mean in the legislation. We'll start off with those general concepts, though, that are essentially broken down to 4 elements. The first is that a workplace delegate is entitled to represent the industrial interests of members or persons eligible to be members, including in disputes with the employer. First element. Second is that a workplace delegate is entitled to reasonable communication with those members or persons eligible to be members in relation to their industrial interests. The third element is, for the purposes of representing those interests, they are entitled to reasonable access to the workplace and to workplace facilities where the enterprise concerned is being carried on. And the fourth element is that the workplace delegate is entitled to reasonable access to paid time during normal working hours for the purposes of related training. Now, that particular element doesn't apply to small businesses. So again, hearing a common word come through all of this, Mitch, that is reasonable. What is reasonable communication? What is reasonable access? And determining the boundaries of those issues is going to be quite difficult. I mean, one issue that arose when I was reading through these provisions sort of jumped out at me was reasonable access to the workplace. Is that essentially a quasi-expansion of the right of entry regime? Extending it to workplace delegates and giving them a right to essentially freely walk around the workplace, even in areas that they have no purpose being for the purposes of their substantive role, to go out and perform their workplace delegates' duties? I mean, in some respects, the answer is going to be yes. Working out the boundaries is going to be more difficult. But as I mentioned, some of these rights have been clarified by the Fair Work Commission in the context of creating the first workplace delegates' rights term in modern awards, which have been required to deal with those issues that I just ran through. So that's probably a good segue to our third topic that we wanted to cover today, Mitch, and that is the delegates' rights terms in modern awards, enterprise agreements, workplace determinations. What do those terms do?
Good question, Rohan. I think the answer to that question is that they sort of build upon, or in effect codify those rights that have been included in the Act since December last year, to say, what does reasonable access to the workplace look like? Although there are some sort of, the model term that is inserted into the modern award is quite broad in its import. It's sort of expanding upon that and building a bit more guidance for employers about, what facilities workplace delegate has the right to access and not access in some respects, including where they do not provide those types of facilities, they don't have those facilities or those types of things available to workplace delegates, or it also takes into account situations where the employer might not have control of that particular workplace. So examples such as service contractors and things like that. But reflecting the need to take, after reasonable steps, trying to gain access to that workplace, it's been made unavailable to them. Things like that nature.
So I think, just to summarise the different sources of these obligations again, before I hand over to you, Mitch, to take us through the award term. For employees who aren't covered by a modern award or enterprise agreement, the source of these obligations is the Act, the general protections provisions that I just ran through. They're very generalised, they turn on what is reasonable. That will require an assessment based on the circumstances of each individual case. For those to whom modern awards applies, then those rights will be dictated by the modern award. And for those who enterprise agreements apply, then those rights, if they have a valid workplace delegates term in them, then those rights will be dictated by the agreement. We'll come back to how the agreements interact with the award terms a little bit later. But I think that brings us to the terms of the modern award workplace delegates rights term. Mitch, do you want to maybe start with what the Fair Work Commission was tasked to do and what they've done?
So, under the closing loopholes reforms to the Act, the Fair Work Commission was required to vary the modern awards to include a workplace delegates rights term. That's now been published by the Fair Work Commission as of Friday the 28th of June, and it builds upon the workplace rights and protections that are already in the Act. This includes details around the parameters of the right of representation, the entitlement to reasonable communication, the entitlement to reasonable access to the workplace, the entitlement to access training, and the boundaries of the exercise of those entitlements, as you've already pointed out. The modern award delegates rights term also contains an additional sub-clause for inclusion in 38 modern awards, where those modern awards already contain workplace delegates rights to some extent, to clarify that the workplace delegates rights that exist in those modern awards only apply to the extent that they are more beneficial to workplace delegates than the model term.
Yeah. So aside from that clause, the same term has been inserted in all 155 modern awards. I suppose that's a good thing for consistency. But there's those 38 where employers who are covered by those awards will need to go through themselves and work out, well, how does that term interact with the existing delegates' rights provisions? I mean, it's one burden that I guess is left in the hands of the employer, but it's no doubt been necessary just given the urgency in which this term has had to be created. Is there a review period in place for this, Mitch? How's that going to be handled?
The full bench has decided that it's appropriate to review the application of the delegates' right term after 12 months of operation. And the full bench also has pointed out during this process that whilst this is a single term that will apply to 155 modern awards, it's now open to the parties to apply to vary the terms of the modern award for industry and occupational specific delegates' rights terms to be included in those awards.
So it's a good call out there for employers listening. Do have a look at that schedule to the statement of the Fair Work Commission that lists the 38 modern awards that also have additional delegates' rights terms that need to be taken into account, and work out whether any of those awards are relevant to your business, because it's worth understanding those. We're not going to go through those in the context of this section.
I'll just say, in respect of those as well, Rohan, that on my first glance of them, I thought these are primarily enterprise awards. However, there are some rather large modern awards with industrial and occupational coverage contained in that list.
Yeah, manufacturing, for example. Yep.
Building and construction on site, etc.
Yep, agree. So let's get into the key elements of the award term itself, Mitch. Maybe starting with the identity of delegates. How do employers know who are delegates and who actually get access to these rights?
So under the modern award delegates rights term, a workplace delegate must give their employer written notice of their appointment or election as a workplace delegate, and a workplace delegate must do this before exercising any of the rights under the term.
Yeah. And do they have to give employers, that's just written notice of the appointment, do they have to prove that through any evidence?
Yeah, if requested, a workplace delegate must provide their employer with evidence that would satisfy the reasonable person of their election or appointment as a workplace delegate.
Okay. And what about if they cease to become a workplace delegate? Is that, if they cease to be one, is that dealt with as well?
Where a workplace delegate ceases their appointment or their position as a workplace delegate, they're required to provide their employer with that notification of the cessation within 14 days.
Great. Now, that will give some employers some comfort. That deals with a lot of the questions that we had coming through ahead of the release of this term is, well, how do we know? At least there is a formal process for dealing with that in the modern award term. What rights does the term provide for representation of employees by delegates, Mitch?
Yeah, the right of representation is quite a broad one, but it only applies in respect of eligible employees who wish to be represented and only in respect of their industrial interests. And a workplace delegate may represent the industrial interests of eligible employees in the workplace in matters including consultation about major workplace change, consultation about changes to rosters and hours of work, the resolution of disputes, disciplinary processes, enterprise bargaining where they are elected as a bargaining representative or they are assisting union officials with enterprise bargaining, or any process or procedure within an award, enterprise agreement or policy of the employer under which eligible employees are entitled to be represented and which concerns their industrial interests.
Which is a pretty broad list, right, in terms of the things that workplace delegates are entitled to be involved in representing employees. There's probably two issues that jumped out to me in that, two questions. One is the reference to bargaining. I mean, query whether the term is now going to be used as a source of alleged obligation for employers to invite more and more delegates into the bargaining room and sit at the bargaining table. It's a big question mark for me. But the other one relates to the absence of reference to performance discussions. So it references disciplinary processes, doesn't reference performance discussions. Mitch, you were telling me before this session that the first draft of the term, which was published by the Commission, did include reference to performance. That's been taken out. Now, query whether that means that workplace delegates don't have the right to represent workers in the context of performance discussions, or alternatively, whether they'll just rely on the broader resolution of disputes heading and just claim that there's a dispute about performance-related issue and therefore the employee needs representation. That just gives you a bit of a snapshot into some of the areas of grey that will no doubt have to be explored as these provisions are tested and we see cases running through the Commission and the courts. That then brings us to some of the more substantive rights, Mitch. And let's start with communication with employees. What guidance does the modern award term give in relation to the scope of the workplace delegates' rights to communicate?
Yes, the entitlement to reasonable communication is also a broad one, but one which is targeted at the entitlement for workplace delegates to spruik the benefits of union membership and representation in their workplace. And the award term states that workplace delegates may communicate with eligible employees for the purpose of representing their industrial interests, which includes discussing membership of their organisation and representation with eligible employees.
And I mean, that's pretty unexceptional. I mean, of course, we would expect the delegates' rights term to include discussions around membership, representation of rights and the like. Does the award give any guidance about the when? I think many of our clients would be interested in, well, when do these discussions take place?
So the entitlement, as you foreshadowed earlier, Rohan, it goes beyond the current right of entry regime, which limits union permit holders to holding discussions with workers during meal breaks and outside of working hours. The entitlement to reasonable communication under the delegates' rights term permits workplace delegates to communicate with eligible employees during working hours. However, this does not extend to union permit holders, of course.
Yes. So, I mean, that's an interesting element of the modern award term. And it does say, I'll just read the words, a workplace delegate may communicate with eligible employees during working hours or work breaks or before or after work. So it'll, again, be interesting to see how that's interpreted. Is it going to be interpreted as a blanket right to always communicate with eligible employees during working hours? In what context? How will that be determined? I think that's going to be interesting to see how that's applied. What about access to workplace and facilities, Mitch? How's that dealt with?
Yes, the employer must provide a workplace delegate with access to or use of the following workplace facilities: a room or area to hold discussions that is fit for purpose, private and accessible by the workplace delegate and eligible employees, a physical or electronic notice board, electronic means of communication ordinarily used in the workplace by the employer to communicate with eligible employees and by eligible employees to communicate with each other, including access to Wi-Fi, a lockable filing cabinet or other secure document storage area, and office facilities and equipment including printers, scanners and photocopiers.
That's a pretty extensive list there, Mitch. I mean, many of those, a lot of the employers who already have delegates' rights terms in their enterprise agreements will be familiar with a lot of these concepts. On the plus side, I guess, at least there's some very specific clarity around the types of facilities that will be on offer. So that can only be a good thing. What about training, Mitch? There's been a lot of attention on this right that appears in the General Protections provisions to paid training for workplace delegates. What does the modern award term do in relation to that entitlement?
Yeah, the modern award term is quite extensive in this regard. What it says is that employers other than a small business employer with fewer than 15 employees must provide a workplace delegate with access to up to 5 days of paid time during normal working hours for initial training, and at least 1 day each subsequent year to attend related training which is related to representation of the industrial interests of eligible employees. This is, of course, subject to some conditions. So, for example, in a financial year, an employer is not required to provide access to paid time or training to more than one workplace delegate per 50 eligible employees. And the number of eligible employees will be determined on the day that the delegate requests that training.
Well, that's, I mean, the limit on how many days of paid training as against the number of employees being represented, I think will be welcomed by employers. I mean, I think that's another common question that have been coming up before the release of this delegates' rights term. That is, well, are there any limits on workplace delegates? I mean, what if we've got a workforce of 50 and 49 of them are appointed as workplace delegates? Now, that can still happen. There is no restriction on that. But what the modern award term does do is limit how many of the delegates would have access to paid training, which, of course, is necessary to limit the impact on the employer of these arrangements and the cost to the employer of them. Are there any other relevant conditions on that you wanted to take us through?
Yes, one of the things that stood out to me was the rate of pay workplace delegates are entitled to during their absence from work to attend that training. And I think that this is something that employers need to be particularly aware of because workplace delegates are entitled to be paid for the hours they would have been rostered or required to work had they not been absent from work. And this will include payment in respect of any penalty rates and wage-related allowances. This will also include payment in respect of any rostered overtime, as the payment is not limited to payment in respect of the workplace delegates' ordinary hours of work, but their normal hours of work.
Okay. And what about notice of the leave? I mean, many employers are going to be thinking, well, how do I actually manage the operation, manage the business, if I'm going to get short notice of workplace delegates having to run off on paid training? How is that managed by the award?
Yeah, the workplace delegate must give their employer no less than 5 weeks' notice, unless a shorter period of notice is agreed to. They must also notify their employer of the dates, subject matter, the daily start and finish times of the training, and the name of the training provider.
Yeah. And in terms of, 5 weeks notice in advance, is there a time period in which the employer needs to provide a response or approval in relation to that request?
Yes, an employer must advise the workplace delegate no less than 2 weeks from the day on which training is scheduled to commence, whether the workplace delegate's access to paid time during normal work hours to attend the training has been approved.
Yeah, and the award clarifies that approval must not be unreasonably withheld. So that's another saving grace, I guess, for employers in the context of these provisions. It's not mandatory to say yes to every request for a delegate to attend paid training, subject to you meeting that entitlement to access to a certain amount of paid training over a period of time, and subject to any refusals being reasonable. That will no doubt be another source of disputation, and we'll see the cases play out and give some guidance as to how that's to be assessed, I'm sure. Now, are there any any broader conditions on the exercise of these rights? Mitchell, I'm conscious there's a long list of entitlements here that we've just run through. Are there any conditions on how workplace delegates are required to behave or obligations to follow in the context of exercising these rights?
Yes. One of the key elements of the conditions that are placed on the exercise of these entitlements recognises that a workplace delegate is still an employee of their employer. And a workplace delegate's entitlements are subject to the condition that they, when exercising their rights as a workplace delegate, must still comply with their duties and obligations as an employee. They must still comply with the reasonable policies and procedures of their employer, including codes of conduct and health and safety policies and things of that nature. Workplace delegate must also not hinder, obstruct or prevent the normal performance of work in the workplace and must not hinder, obstruct or prevent eligible employees from exercising their rights of freedom of association.
Yeah, and that's really important, isn't it, Mitchell? You think about that, the obligation of the delegate to not hinder, obstruct or prevent the normal performance of work. Yet they also have those countervailing rights to, in some circumstances, hold discussions during working hours, to take paid leave and the like. So there's a necessary tension there that a balance will need to be found and struck between those countervailing entitlements and obligations. So it's going to be interesting to see how that plays out. Importantly, there are also some constraints on what workplace delegates are entitled to in relation to employee contact details. Mitchell, did you want to cover that briefly?
Yeah. The award term makes clear that an employee is not required to provide a workplace delegate with access to electronic means of communication in a way that provides individual contact details for eligible employees.
Yeah. The delegates term also does clarify that none of this compels any individual employee to actually be represented by a workplace delegate. So, as we would expect, consistent with the principles of freedom of association, there is no obligation on employees to have this type of representation. So the award makes that clear as well. So, I mean, there's a lot to digest there, Mitch. There is some extra clarity that's been given beyond perhaps what sits in the Act, but there's still some elements that will turn on the particular circumstances of the case and on concepts of reasonableness. So again, very important that employers take an advanced look at these provisions and give some thought to how they will apply them based on scenarios that they feel might arise in their own workplace. Which brings us, I think, to the final topic, Mitch, topic number 4. What does this mean for employers? We'll break this down to two parts. We'll deal with it firstly in the context of employees to whom a modern award applies. How does the delegates term affect them, and what advice do we give to employers in complying with these new obligations?
I think that the starting point for employers is to understand what these rights are and what the modern award delegates rights terms actually say. I think that it's having a think about what their interaction with workplace delegates has been in the past. Who are the workplace delegates in their workplace? Where have they engaged with them? And where the sort of heightened risk of non-compliance might exist for them with complying with these terms. I think that it's important that employers ensure that all internal policies and procedures are updated to ensure that that the balance is reflected between what are these workplace delegates' rights entitlements, and then what are their obligations, and how are these going to be reflected, and how are they going to detail expected standards of behaviour and ensure that there are clearly defined and understood protocols for both workplace delegates and for their frontline managers who will inevitably be tasked with engaging with them.
Yeah. Look, I agree, Mitch. It's very much worth getting ahead of all of this, not waiting for the exercise of the rights themselves to work out what the employer's response will be. And there's always a lot of value in actually setting those understandings through discussion and consultation with delegates in advance and trying to unearth any different points of view ahead of time. It's obviously going to prevent disputes that way, if at all possible. And of course, if the employer complies with the modern award delegates term, then they're deemed to have also complied with those countervailing provisions that sit within the general protections provisions. So there's no need to consider both in that case. And what about enterprise agreements, Mitch? For those employers that have enterprise agreements within their business, how does the modern award workplace delegates term interact with those agreements?
So where an employer has an existing enterprise agreement, they'll only be required to comply with the rights that are contained in the Fair Work Act, which Rohan spoke about before. But for enterprise agreements where a ballot or vote is commenced on or after 1 July 2024, that enterprise agreement must contain a delegates' rights term that is at least beneficial or more beneficial than the modern award term that is contained in the underpinning modern award or modern awards.
Yeah, that's right. So, I mean, from here on, we're now post 1 July 2024. For all employers negotiating enterprise agreements now or looking to do in the future, this is a new issue that has to be considered in preparing the draft of your proposed agreement. You need to have a look, are there existing delegates' rights terms? If so, how do they marry up with the award provision? Are they more beneficial? If not, then you'll need to have a look at the terms of the award and ensure that they're built in to the agreement before it goes to vote. Otherwise, the modern award term will apply as a default. So we'll see increasingly over time, gradually the award term will trickle into enterprise agreements as new ones are negotiated and replaced, and we'll see a new standard take place across all employers, whether covered by awards agreements or otherwise. So there's a lot of work to do there, Mitch, for employers, and I think I'll just reiterate the suggestion that employers have a read of the workplace delegates' rights term in your relevant modern awards, have a look at those general protections provisions that we referred to, and start to think about the scenario planning. What are the scenarios you think might come up in your workplace? What do you think is the appropriate response to those scenarios to ensure compliance with these principles? Start educating your line management about those issues. They're the ones that are going to have to deal with these scenarios as they arise on a day-to-day basis, and it's important they're educated about the need to comply with these new provisions. So please, look, it's no doubt another issue that employers are going to have to grapple with and get across in conjunction with the myriad of other reforms, industrial relations reforms that we've covered on the last 20 or so episodes of Inside IR. So please reach out to a member of your friendly HSF industrial relations team if you'd benefit from a tailored briefing on these issues, or simply if you have any questions. And otherwise, as always, we love to hear feedback on Inside IR, so please comment, direct message, or send us an email to insideir@hsf.com. Otherwise, we look forward to you joining us on our next episode of Inside IR.